what is I want to before I start a couple of things. That is this Consumer Protection Act, although it says it is a Consumer Pro Act, as has always been since 1986, but a detailed study would tell us that it is not only about a civil law. There are many sections of the Indian, if you look at the basic structure of our legal system in our country, we have the constitution at the topmost. Then there are many other acts and laws and sections, subsection and whatnot. So we very commonly know कि ठीक है 304 एक डॉक्टर्स के अगेंस्ट लगता है, 302 एक punishment for murder होता है and things like that, 376 रेप के लिए होता है. So Indian Penal Code contains the laws which include which describe many crimes and punishments for them. Then there is CRPC, Criminal Procedure Code, which has got many, procedures for working out crimes and many punishments also regarding the IPC. Then there is the IEA, or called as the Indian Evidence Act, which has got the rules and regulations of governing evidence taking in a court of law. Why I'm telling you this? Because this consumer protection is so draconian, I would say, without any hesitation, because it has included many sections of the Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act into the Consumer Protection Act itself. Now, as a principle, Consumer Protection Act is a civil law. In civil law, what do we talk about? We talk about fines. We talk about damages. Okay, we never talk about punishments. But this is one civil law which has got now punishment. ठीक है, वो पहले भी था, but पहले बहुत कम था. अब इसमें बहुत ज़्यादा बढ़ा दिया है. And not only that, okay, as a consumer, I would say कि yes, I want that person to be punished. Okay, fair enough. But then there are many other sections of Indian Penal Code like injury, harm, which have been included into the Consumer Protection Act 2019 itself. Okay, so with this basis, I like to move ahead, and the first thing that is very as the name says, it is pro-consumerist, and whenever there is something, when we study law, we talk about balance in the society. There is nothing like pro one segment of the society. This particular act itself says that it is meant for consumers, and and as compared to 86, as Dr. Kohli rightly said, it has become more pro consumer. So there is as per section 17, provision for electronic complaints under the act, where a person complainant can make a complaint from the comfort of his home. So there is easy access to courts, can be filed in a from a place where the complainant resides or works, in a court where it is situated. And therefore the fallout, what is the fallout? It encourages complaint. अगर किसी के दिमाग में thought भी आता है कि हाँ ठीक है complaint करते हैं, he just has to log in onto the internet and file a complaint. Everything, including all evidence, all papers, everything can be filed online. So that is one of the biggest things. So all this around 15-20 things that I have taken out from the CPA 2019, they are not in an order. They are probably more likely in an order of the severity that it affects the traders or service providers like healthcare professionals or medical professionals. The second thing is the penalties. As a consumer, okay, as Dr. Kohli also said, a consumer would want कि ठीक है उसको ज़्यादा punishment मिलनी चाहिए, ज़्यादा damage मुझे मिलनी चाहिए कि उसने इतना बड़ा गुनाह कर कैसे दिया, So penalties are more. And what is the fallout of these penalties? For misadvertising, the penalties go for as much as punishment of 2 years plus fine of 10 lakh, which can increase up to 3 years, and 50 lakh rupees, which is the highest. 50 lakh, just half a crore rupees for misadvertising. Of course, if some corporate hospital is doing it, then but then this I think is more in line with the so many products that are there in the FMCG products on the internet or advertising on the television, for whom this is meant. But then anyway, it applies to every sector of the society. Failing to carry out directions of the consumer code, for example, doctor के against जो award pronounce हुआ है कोर्ट से, उसके लिए the doctor can be punished for up to, or the healthcare sector hospital, up to 3 years in jail and 1 lakh fine, which is much more than what it was previously in 1986, failing to carry out directions of the Central Consumer Protection Authority. Now I'll talk about this authority in a bit, but the punishment is also there for that, 6 months plus 20 lakh fine. And for manufacturer or importer, it can go up to life imprisonment. Life imprisonment, as I was talking about, कि IPC में इतनी punishment होती है, इतनी severe. So obviously, if a class of person, many people die because of a faulty product or a service, then the punishment for the service provider or the importer or manufacturer of that medicine may go up to life imprisonment plus 10 lakhs fine. So this particular Consumer Protection Act has increased the culpability of offences that may be committed against the consumers or our patients. This is another part. Then there is about the scope of Central Consumer Protection Authority. So there are these sections 18 to 21 which cover this. So what is this authority? So this authority has been made under the CPA 29 itself by the central government. And what does it do? It takes care of many rights of consumers, be it our patients. So there is a kind of, two authorities. One is the Consumer Court itself, and another is the CCPA. So ideally, it is meant to enforce the rights of consumers and prevent unfair trade practice under the CCPA itself, and seize false advertising, inquire into violations. But then the fallout is that now we have two authorities to answer to. So there is many. I try to study as far as the rights, although each and every right in detail is described in the Act itself. But there are many levels at which there are gray areas, because when a person goes to the consumer court, then he would be challenging these rights of unfair trade practice by the service provider or the seller of medicines or a hospital. So there is a gray area. The same thing is governed. So the consumer now has a choice. The patient is now has a choice. So there are two authorities for the same issues. Already, I was just sharing with you all guys that there are almost 14 authorities where for the single act of alleged medical negligence that the patient can approach to. Okay. And what can the doctor do? He's got only 3 or maximum 4 authorities where he can go, So this is one more in the CPA itself, that there are, the patient has a choice. He can go directly to the authority as well as to the consumer court for the same grievance, So the another part of the CCPA authority is that it is made on the directions of the central government. So although it is an autonomous body, but its scope may be restricted by the central government itself. So this is one conflict of interest with the authority. I'll give you an example. For example, if there is this talk about COVID-19 vaccine industry, and the manufacturer says that, okay, it is likely that, because now there is a provision of class action suits under CPA 29, which was not there earlier. So if the manufacturer says, okay, so many people are likely to die, I want protection from this. So the authority has that role. It can give a kind of immunity, जो उन्होंने मांगी भी थी जब कोविड-19 का वैक्सीन आया था 2 साल पहले. तो although government ने दी नहीं थी, but yes, this is very much possible. Same goes for electric vehicle battery industry. If they say कि we are new, we want so, एक तो income tax वगैरह वो अलग बात हो गई, but अगर वो अथॉरिटी को बोलते हैं कि वी वांट प्रोटेक्शन, कि हमारी वजह से गाड़ी को कोई डैमेज हो या वो, तो हमको थोड़ा प्रोटेक्शन दिया जाए फॉर ए फ्यू नंबर ऑफ इयर्स. सो माय पॉइंट हियर इज दैट the CCPA authority has got parallel authority as compared to consumer courts, where it can take decision on the same matter as the consumer court itself. Although ये awareness की बात है, see, it is because of awareness that patients are putting up cases against doctors. They were not earlier. And the same awareness, if it comes into public की ठीक है एक parallel authority भी है, अब डायरेक्टली वहां चले जाओ, कोर्ट का झंझट बढ़ गए, बिकॉज सीसीपी के पास ज्यादा केसेस नहीं होते हैं. इट विल केस अप एनी केस डायरेक्टली and it will pronounce orders very quickly. So what are the powers? The CCPA has powers to cancel license. डॉक्टर की डिग्री है, उसको कैंसिल कर सकता है, या हॉस्पिटल का लाइसेंस कैंसिल कर सकता है. can order for immediate shutdown of the hospital. It can take action on its own motion, suo motu action जिनको कहते हैं legally, or it can order for reimbursement. Now, this is the biggest conflict of interest, I would say. Reimbursement और damages order करने की authority courts को होती है, but यहाँ पे CCPA को भी है. So you can see, the patient can get their job done very easily through the CCPA in spite of the consumer code. Then there is a talk about unfair trade practice as per section 2, subsection 47, where it is defined that unfair trade practice is a, now this was although earlier there, but it was not described in so much detailed as it is in the 2019 Act. Unfair trade practice is where we find that pricing of a service has been unfair in its own judgment, okay, as decided by the CCPA or by the consumer court. So can the court order for restructuring the price of a package? For example, if the court finds that ठीक है आप एंजियोप्लास्टी करा रहे हो, हिस्टेरेक्टमी करा रहे हो, ठीक है, या कोई और ट्रीटमेंट कर रहे हैं किसी भी स्पेशलिटी में, तो उसका प्राइस ठीक नहीं लग रहा है, तो CCPA has that power to order for restructuring of that price. Now एक तरफ तो हम empaneled कंपनीज की बात करते हैं और गवर्नमेंट की बात करते हैं कि उन्होंने इतने पुअर पैकेजेस दिए या वो उनको कोई वो इंटरफेयर नहीं करने चाहिए, बट here we have another authority, the CCPA, which can possibly do that. हाँ, किया नहीं है, but then what is stopping the CCPA from not doing it? Then another example is the unfair trade practice says that having such terms which cause significant change in the rights of such consumers, that means falsely representing standard or quality. I'm trying to share with you all what does an unfair trade practice actually constitute. Falsely representing the standard of a quality or a product that we are selling from our hospital, medical establishment, the quantity, the composition, or we are selling some old product as new, affiliation with a particular agency, which might give brownie points to our services or our medical establishments, usefulness of a particular service. अब इतने ट्रीटमेंट करते हैं, हम कहते हैं कि ठीक है आपके पास 2 या 3 ऑप्शन है, इसका ये फायदा है, इसका ये फायदा है, अगर कुछ मिसअप हो जाता है बाद में कहेंगे आपने तो ये बताया था इसका फायदा ये. So this would constitute unfair trade practice, although we are not a trade, but then we are a trade because the law considers it our services as a trade now. So guarantee तो ठीक है, courts कहते हैं guarantee नहीं होती. Advertising ठीक है, हमको वो भी allowed नहीं है, but corporates do advertise, don't they? So the scope of unfair trade practice has increased substantially. और इसमें if you start, these are all 8 to 10 adjectives that I have pointed out here for all of us to see. You think of any service that we are providing as a doctor, and almost every कोई ना कोई adjective में हमारी service जरूर fit हो जाएगी इसमें. So I don't know with what mind, and there's so much of pro-consumerist attitude in this particular law that they have totally forgotten that the traders or the sellers or the service providers are also human beings from the same society. It is so I would say draconian in that particular respect. Then there is a talk about product liability under this act, that there is a provision for compensation to the consumer for a fault in a product. Now what does this mean? ठीक है, fault in product हो गया, उसको वापस कर दो, ठीक है, बट CCPA की अथॉरिटी ये है और कंज्यूमर कोर्ट की भी है कि नॉर्मली जो कंज्यूमर लॉ इस पे बनी है कि अगर डैमेज होता है पेशेंट को किसी भी तरीके से तो उसके लिए कॉम्पनसेशन मिलता है. बट प्रोडक्ट लाइबिलिटी में इन्होंने ये प्रोविजन बनाया है कि अगर डैमेज उसको नहीं भी होगा कंज्यूमर को, पेशेंट को, तो भी उसको कॉम्पनसेशन मिल जाएगा. उसने सिंपली प्रोडक्ट खरीदा बट डैमेज नहीं हुआ, उसको कॉम्पनसेशन बनता है बिकॉज अंडर द provision of class action suits. So this is the extent to which this pro-consumerist attitude of our lawmakers is going. Then about the pecuniary jurisdiction, when we use the word pecuniary, I hope we all understand that it relates to money. Okay, so as far as the that the district commission has a limit of up to 50 lakhs, the state up from 50 lakhs to 2 crore and national commission from more than 2 crore onwards. It was changed in December 2021. Earlier it was a bit different. So this is based upon actual consideration paid. What is different from 1986 Act? We must understand, my dear friends, that this is a very, very, very important point. You know, पहले ये होता था कि ठीक है, अगर पेशेंट ने 2 करोड़ की कॉम्पनसेशन मांगी है, ये 2 करोड़ 20 लाख फॉर एग्जांपल, तो वो सीधा का सीधा नेशनल कमीशन में जाएगा. ठीक है. अब ये है कि अगर उसने खर्चा तो किया है सिर्फ 12 लाख रुपए का ट्रीटमेंट में, जो उसने पे आउट किया है हॉस्पिटल को, बट कंपनसेशन मांग रहा है वो 2 करोड़ 20 लाख की, तो अब वो केस नेशनल कमीशन में नहीं जाएगा, वो डिस्ट्रिक्ट कमीशन में जाएगा. तो इसका फॉर एग्जाम्पल एक और मैंने इसमें एग्जाम्पल लिया है कि अगर किसी फ्लैट परचेजर ने 1 करोड़ प्रॉमिस किया था बिल्डर को देने का, तो वो सीधा नेशनल कमीशन में नहीं जा सकता. ही विल हैव टू अप्रोच द डिस्ट्रिक्ट कमीशन. उसका नुकसान क्या है? नुकसान ये है कि डिस्ट्रिक्ट कमीशन आर full of more than 90% of cases in under this law are going to the district commission. और उसमें क्योंकि लिमिट सिर्फ 50 lakhs की है, इट डजंट मैटर कि वो 100 करोड़ मांग रहा है कि वो 12 लाख मांग रहा है. वो केस जितना उसने खर्चा किया है, दैट इज द इंपॉर्टेंट डिफरेंस. सिर्फ उसके हिसाब से ही पिक्यूनरी जुरिस्डिक्शन बनता है. सो दे आर ओवरलोडेड विद वर्क एंड of course we all know कि hospitals में जब overloaded होते हैं, we all have worked in government hospitals or maybe even some corporate hospital which got a high workload, the quality of work goes down, the quality of judgment is going to go down. The courts will be in a hurry to pronounce judgments without hearing. It is our job to visit courts and see how they work. जिस तरीके से वहां पे बिफोर यू टेक ए ब्रेथ एंड रियलाइज व्हेन ए पेशेंट कम्स टू अ क्लिनिक, फर्स्ट टाइम आता है, तो वो पहले चारों तरफ दीवार फेमिलराइज करने में उसको 1-2-4 मिनट लगते हैं. कोर्ट में आपको 2-4 मिनट लगे ना, तब तक आपको पता लगेगा आपकी केस की हेयरिंग हो भी गई है, नेक्स्ट डेट भी दी है, एंड यू आर सपोज टू आउट ऑफ द कोर्ट. सो इतना क्विकली वर्क होता है इफ यू आर नॉट वेरी फोकस्ड अबाउट योर केस. इट हैपेंस सो क्विकली सो मेनी टाइम्स. I have attended more than 1,000 presence in criminal courts, mostly consumer court में तो rarely, but I have seen how they work. जब जैसे criminal court में होता है वैसे consumer court, they are very fast. They got pressure to dispose of cases early, so we know what is the quality of we have advocates in family who share things, how they work, and they are all laughing out कि इतनी जल्दी ऐसा काम होता है कि जस्टिस की तो बात ही भूल जाइए. अगर आपकी बात ही सुन ली, यही बहुत बड़ी बात है. So this is the good part that was there in the CPA about mediation, and it was about matters pertaining to medical negligence resulting in grievous injury or death will not be referred for. Did we know this point? We always say कि mediation अच्छी बात हुई है, but you see how biased this act is. This is probably the strongest bias they have in the mind of society, the lawmakers who have made this law, that ठीक है बाकी सब चीजों का तो ठीक है, but if a patient has died or he has suffered grievous injury, then that case cannot go for mediation, even if the patient wants कि ठीक है ओके, अगर वो कन्विंस हो भी गए मीडिएशन करके जो भी कंपनसेशन का देना है आप दे लो थ्रू द कोर्ट चैनल इटसेल्फ, बट द लॉ डज नॉट अलाउ दैट. एंड दिस द फर्स्ट पॉइंट that they have written under points of mediation. Mediation के rules बाद में आए थे और उसमें first point लिखा है कि medical negligence से pertaining जो भी issues होंगे वो especially resulting grievous injury or death, they will not be allowed for mediation. Mediation के exceptions में आता है. Now this also means that कि अगर पहली बात तो negligence prove नहीं हुई है कोर्ट में, ठीक है, और बिकॉज मीडिएशन में जब फर्स्ट डेट होती है कंज्यूमर कोर्ट में ना, द फर्स्ट डेट पे द फर्स्ट थिंग दैट द प्रिसाइडिंग ऑफिसर इन द कोर्ट विल आस्क बोथ द पार्टीज इज टू सेव टाइम ऑफ द कोर्ट, सिंस दिस मीडिएशन फैसिलिटी इज देयर एज पर सेक्शन 44 in the CPA 2019, that do you want to mediate? If both the parties say yes, then in the first date itself the court will refer both the parties for mediation. वो सेल अलग बना होता है कोर्ट में, ठीक है. बट इस केस में मेडिकल नेग्लिजेंस में फर्स्ट डेट पे अभी तो केस एडमिट हुआ है, ये तो बात की बात है कि पहले प्रूव हो मेडिकल नेग्लिजेंस है कि नहीं है. बाद में पता चला मेडिकल नेग्लिजेंस थी ही नहीं, ठीक है. तो अब पार्टीज को मेडिकल नेग्लिजेंस प्रूव करे बिना ही फर्दर प्रोसीडिंग्स के लिए उन्होंने मना कर दिया कि ठीक है मीडिएशन नहीं कर सकते, ये तो बाद में पता चल रहा है. सो दिस इज ए प्रिंसिपल ऑफ नेचुरल जस्टिस की हम बात करते हैं, उसके तीन बहुत बड़े प्रिंसिपल होते हैं. पहला प्रिंसिपल होता है कि बोथ द पार्टी शुड बी हर्ड, एंड दिस इज वायलेटिंग दैट प्रिंसिपल ऑफ नेचुरल जस्टिस कि वो पार्टीज को अभी हियर तो किया ही नहीं है कि उनकी इश्यूज क्या है, और पहले ही बोल दिया कि ठीक है you are not allowed for mediation, So this is a very strong bias in this against the healthcare sector, against the medical professionals as far as mediation is concerned. Then judgments of consumer courts and अच्छा इसमें एक और चीज थी. I was talking about grievous injury. Now grievous injury again it is a criminal law as per 320 Indian Penal Code. तो पहले कोर्ट को वो भी डिटरमिन करना पड़ेगा कि ग्रीवियस इंजरी है या नहीं है. तो इसमें एज आई वाज सेइंग कि देयर इज talk of injury, there is talk of harm, there is talk of grievous injury that has come into the Indian Penal Code, that has come into the consumer protection law itself. So judgments of consumer courts and they're heavily pro-consumerist CPA. It results in indirect discrimination, harassment, and victimization of service providers, including medical professionals. Just to summarize, it is not only about damages, but the courts have already made up their mind that they have, which is resulting in discrimination, harassment, and victimization of medical professionals. And that is what is the perception is there in the society. Another very good point that came out of this is that Supreme Courts have very categorically accepted and stated more than one judgment is that medicine is an inexact science, as per this case of Martin D'Souza versus Mohammad Ishfaq Khan, 2009. And they've also said that no treatment is 100% successful as far as medical science is concerned. What is the fallout? Fallout is that the Consumer Protection Act exploits these facts despite knowing these facts and awards patients for unpredictability of medical science. So we've got two branches of law. One is Supreme Court or the common law that accepts these facts and says that yes, medical science is inexact, and despite knowing the fact, another branch of law says that I'm going to exploit this fact and award damages to the patient for this. What can be a bigger fallacy than this? Come to think of it, एक तरफ तो हमारी मशीनरी एक्सेप्ट कर रही है कि we are in inexact science and no medical treatment is 100% successful. These are laid down laws at several points in the time in the past, about 25-30 years. But despite that, another law says that I am going to exploit these weaknesses of medical science and award you damages for the same, as far as advocates, although I'm a legal professional, but I vowed not to become an advocate in my life. And advocates, just because every judge is first an advocate and later a judge, and because of this very fact, in the case of DK Gandhi versus M. Matthias in 2007, it has not vacated a stay granted in a particular case of a lower court. This is of a Supreme Court. This case is from Supreme Court. Lower court ने कहा था कि medical professionals, High Court ने the legal advocates, they are under the purview of Consumer Protection Act. But Supreme Court ने उस पे stay डाल दिया because they are providing service to law. Aren't we providing service to medicine? It's a funny argument. On this, the advocates are exempt from Consumer Protection Act. Medical professionals are not. I mean, this is one of the most foolish judgments of the Supreme Court, I would say. I don't know, there might be more. So we have got, kind of a double jeopardy. Although this term is a legal term, I'm using it just for fun, that the doctor is between two things. Not only the consumer protection law, but also the provision to file complaint for unfair trade practice under the Consumer Protection Authority. For a single act, the patient can go to both the authorities and obtain compensation. और उसमें क्या होता है, CCPA में अगर हियरिंग होगी, उसमें एक सिंगल हियरिंग होगी, जो भी मेंबर्स बैठे होंगे हेयर करेंगे, एंड दे हैव मेड अप देयर माइंड, दे विल प्रोनाउंस जजमेंट, और उसमें और कुछ नहीं होता है, अनलेस लाइक ए कोर्ट, And there is this section on unfair contract. So there is the Indian Contract Act of 1872, much before independence, one of the oldest law existing for our country. So that contract law has also been included in this. तो सीपीए तो एक ऐसा हो गया कि ठीक है, जो भी कानून पसंद आ रहा है उनको उसको प्रो कंज्यूमरिस्ट बनाने के लिए इंडियन पेनल कोड भी डाल देते हैं, हम उसमें कॉन्ट्रैक्ट एक्ट भी डाल देते हैं, हम उसमें कंसेंट की बहुत सारी जजमेंट्स हैं, कंसेंट भी और ज्यादा इसमें वो हो गया है डिटेल्ड, वो भी डाल देते हैं, और इंडियन एविडेंस एक्ट को वहां से निकाल लेते हैं क्योंकि इंडियन एविडेंस एक्ट की ज्यादा डिटेल्स हैं वो अप्लाई नहीं करते. और so unfair contract has been defined in this particular law as a contract between a manufacturer, trader or service provider on one hand and a consumer on the other, having such terms which cause significant change in the rights of consumers. So as part of this, it requires excessive what is not allowed is security deposits. Excessive word use kiya hai court ne. This is as per law. We are not allowed to demand that from our patients. So this thing will go gradually. Okay, एक moderate सा, एक nominal सा amount ही allow करेंगे. Then imposing any penalty on the consumer for breach of contract cannot be done. ठीक है, कि either you take this package, or if you are not taking this package, or if you leave treatment, then your money is gone. This act clearly says the money उसको refund होना होगा, उसको करना पड़ेगा, despite the package or whatever, So this part is there. This will be very difficult to deal with, especially by corporates. So imposing on the consumer any unreasonable charge, obligation or condition which puts such consumer to disadvantage. So the same example could be used here, but then अगर उसकी वजह से, for example, dialysis के लिए पैकेज दिया, अब a same equipment can be used, जो पैकेज आता है for 2 or 3 patients. अब एक पेशेंट ने लिया, दूसरे ने पहले तो उसने कहा ठीक है मैं आ जाऊंगा, फिर पार्ट पेमेंट करके वो चला गया, ठीक है ना, अब वो बोलेगा कि अब हमारे तो नुकसान हो गया ना हॉस्पिटल का, बिकॉज दैट इक्विपमेंट नॉट यूटिलाइज, और हमने एक पर डिवाइड किया कॉस्ट इनटू 3, और एक पेशेंट आया, 2 नहीं आए, तो उसके लिए अगर हम पेनल्टी पेशेंट पे लगाना चाहें और रिकवर करना चाहें, उसमें कोई प्रोविजन नहीं है, बिकॉज लॉ के हिसाब से ये अनफेयर कॉन्ट्रैक्ट है, so unfair trade practice, unfair contract, all this is now part of the CPA 2019. CPA 2019 also has very details about the rights of patient under section 2 subsection 9. As consumers are already inscribed, the rights are already inscribed under the consumer protection. अभी जो latest development, I don't know, आपने सोशल मीडिया में देखा होगा, और इनफैक्ट पिछले 2 दिन की ही बात है, राजस्थान में ये एक नया राइट टू हेल्थ बिल उनके विधानसभा में आने वाला है बाय द गहलोत गवर्नमेंट, एंड आईएमए राजस्थान इज फाइटिंग एक्टिवली अगेंस्ट इट. सो राइट्स ऑफ पेशेंट्स तो ऑलरेडी इसमें है कंज्यूमर प्रोटेक्शन एक्ट में, बट एक राइट टू हेल्थ बिल, अगर राजस्थान सेज, गहलोत सेज दैट आई वांट टू बी द फर्स्ट स्टेट इन द कंट्री वेयर आई वांट टू हैव दिस राइट टू हेल्थ बिल फॉर माय पेशेंट्स. ना उसको देखा देखी बाकी स्टेट्स अगर करने लगेंगे तो देश का क्या हाल होगा, and in fact the bill has only about treatment. It is not talking about right. When we talk about the WHO, the entire world, we talk about the full health of the patient as an individual, as a human being. Sanitation की बात करते हैं हम, food की बात करते हैं, we talk about the environment, and then we also talk about treatment. But this right to health bill is actually a right to treatment bill. It is not about all other things. So you can see how one-sided the state governments are going to, are attempting to put rights of patients into their hands. Totally one-sided. So this again will raise one more avenue where patients can approach the government and the courts against doctors. So as I was talking about, the harm is a proper Indian Penal Code section which has been included in here. Then the injury is simple injury, grievous injury, Their Indian Penal Code standalone sections, they have been included here. And the act also talks about restrictive trade practice. तो पहले तो इसमें although we have a judgment कि that a hospital cannot force its patients to buy medicines from in-house pharmacy, but now this has become part of the. This is just an example. It does not talk about medicines. It simply says restrict trade practice. Forcing patients to buy medicines or any other surgical product from the in-house pharmacy only, is a restricted trade practice. So this has become part of Section 2, subsection 41 of the CPA itself. Then refusing to take back product. Now, you might be surprised. We buy products from Amazon and so many things. Only yesterday, I've returned a request for a product from Amazon to be taken back. Amazon clearly says that the window is of 10 days only. But the law says that that window should be of 30 days. सो अगर कोई प्रोडक्ट पेशेंट ने लिया, ठीक है, प्रोडक्ट डिफेक्टिव है, ठीक है, उसको बट उसको वापस लेना, इट्स नॉट अबाउट रिपेयर. द लॉ सेज दैट विद इन 30 days द कंज्यूमर कैन रिटर्न दैट प्रोडक्ट और द सर्विस हैज टू बी सीज्ड. अगर उसको ठीक है, दैट इज अंडरस्टैंडेबल. बट देन 30 days long window for return of product is like, you buy a white good appliance from the store, even we do not know that we can return it within 30 days, if it is not working fine or defective or whatever. The company normally, what do the seller says, sir, service center call kijiye, wo karega. But then, of course it's got advantages, but disadvantages, that same thing that has been going to any other product, then it falls upon us as medical service providers as well. There is search and seizure. This is part of the criminal procedure code. All these things are, incorporated into the Consumer Protection Act 2019 now. Of course, इसके लिए force आएगी along with the people from Central Consumer Protection Authority. And as far as lastly, this just a couple of slides. The time period for appeal to a higher court from district to state, state to national, national to Supreme Court was 45 days. Now it has been reduced to 30 days. So, of course, there will be less time to prepare for an appeal under this act. And there is normally what happens is that, many other laws, for appeal, चाहे वो patient को, for example, 50 lakhs award किए, ठीक है, कोर्ट ने, तो चाहे वो पेशेंट उसके अगेंस्ट जाए, चाहे डॉक्टर जाए, उसको 25 lakhs पहले डिपॉजिट करना पड़ेगा और तभी वो हायर कोर्ट में जा सकता है. अब यूजुअली जहाँ टैक्सेशन मैटर्स होते हैं या जब भी, वहां पे एग्जम्पशन का कुछ ना कुछ प्रोविजन होता है, बट CPA has made it that there is no exemption in that limit of 50% of the claim amount to be deposited by the person appellant. Appellant could be anybody, चाहे वो डिफेंडेंट है और चाहे वो कंप्लेनेंट है. So this is also there in the CPA Act. Now, डॉक्टर अगेंस्ट तो वैसे वो फाइट कर रहा है कि मेरी नेग्लिजेंस नहीं है, बट ही इज वेरी मच कन्विंस्ड कि ठीक है, आई डोंट डिजर्व दैट टू पे 50 लाख रुपीज, तो वो 25 लेकिन उसको कराना ही पड़ेगा. मतलब तो लॉ इज फोर्सिंग कि भी आप अपनी मान लो गलती और आपको ड्यू टू वट यू हैव टू पे अप दैट अमाउंट. अब इसमें ये इशू भी आ जाती है कि मैं अपील में जाना चाहता हूँ, चलो ठीक है, नाउ will my insurance company deposit 25 lakh rupees, because this is not clear in the indemnity insurance policy that I am talking about, so insurance company तो बोलेगी कि नहीं ठीक है हम दे देते हैं, या फिर 25 lakh अगर वो, because this is, we'll have to see with time where it goes, because में clearly अभी indemnity है नहीं है ये बात. Of course, this does not apply to the pre-2019 Act, the 1986 Act of depositing 50% of amount. So as far as ठीक है, गलतियां तो बहुत निकालती, but solution I don't see honestly any solution. But as Dr. Kohli rightly pointed out that yes, amendments are a solution, petition in Supreme Court, petition to the president, but and of course the IMA, our biggest body of doctors, has to be part of that, and we can only hope that there is a a good future for us. But otherwise, the not only the society but the lawmakers also consider doctors as next to devil, if not next to God. So that is it from my end. Thank you so much.
Dr. Gaurav, ma'am, you like to comment?
Yes, it has been a great exposure on every aspect of Consumer Protection Act, and I think all of us who are hearing it are already
Very.
feeling very depressed after these two presentations. Uh, but what I can say, I will probably go on the Dr. Kohli's line as being an optimistic, that please practice clean documentation, proper consents, proper counseling. All these things are going to probably save us. And pray morning and evening to that, we should not get any cases against us. I think I will, my colleagues will question.
Ma'am, Dr. Kohli has to speak on the what are the various amendments.
Amendments.
So I'll invite you, Dr.
I
Kohli.
think Dr. Kohli, you must speak, because I think you should speak on a positive note. So all of us are very depressed. We have a down faces.
It's so
So
scary, ma'am, after listening to Dr. Gaurav.
We'll want to have inputs from Dr. P.N. Tiwari after Dr. Kohli.
yes, that's surely.
So, rightly said, the CPA 2019 is very lopsided in favor of the consumers. Some amendments are suggested for balancing the legal interests of all the stakeholders. We should forget any chance of being brought out of the ambit of CPA. We have to learn to live with it. IMA and other medical professional bodies should work to introspect and think out of the box to improve doctor-patient relationship in general and the lacunae in the healthcare ecosystem in particular. It's only then that the government and the lawmakers will listen to us and understand our pain. After that much is achieved, we should strive for some amendments with far-reaching benefits. So firstly, about the professional bodies. IMA and other professional bodies have to gear up, introspect, and make measures to improve their credibility before the public and the authorities, devise mechanisms to improve doctor-patient relationship, create conditions where the lawmakers take them seriously in health-related matters, enforce good, clean, ethical practices among its members, where there is objectivity, transparency, and sensitivity reflected while handling patients and their family members. Develop guidelines, clinical pathways, and SOPs for most of the common clinical situations and educate its members on these. If a doctor has treated his patient on the basis of these standard guidelines, even if the outcome is adverse, it does not amount to negligence. Bring unity in the fraternity, though a very difficult task, so that it is seen as a composite block rather than as a divided house. Another important amendment that I would advocate is screening. In medical negligence complaints, screening by a medical board should be made mandatory before the complaint is admitted. This is very easily achievable. This will eliminate, obviously, false and frivolous complaints to a large extent. If the medical board states that there is no negligence, the complaint be barred from being taken up in consumer courts, but may well be allowed in the civil courts. If the medical board states that prima facie there is deficiency of service or negligence, nobody will grudge the case being admitted for adjudication in the consumer court. Then the penalty clause. Penalty clause for false and frivolous complaints be reintroduced. In the CPA 1986, there was a penalty clause for false and frivolous cases, but it was capped to a maximum of 10,000 rupees only. In CPA 2019, it has been removed altogether. The penalty be made, secondly, the penalty be made proportionate to the amount of compensation claimed. It may be, say, 50% or 30% or 25% of the claim amount, but it should be proportionate to the compensation that the complainant has claimed. False and frivolous complaints should be clearly defined with clear objective criteria and not left to the subjective discretion of the judge. This will not only serve as a deterrent for false and frivolous complaints, but will also ensure that the compensation claimed is not unreasonably high and exaggerated. This will be an important facet of checks and balances in the CPA. Encourage mediation. Mediation is allowed in medical negligence cases, but only in simpler cases. It should be allowed in all cases of medical negligence, even in cases of death or grievous injuries. Then an independent medical board should be made available to assist the parties in mediation to understand the intricacies of the medical issues and practices. Modalities of such assistance can be thought of to make it more practical. This will resolve most of the cases to the satisfaction of both parties, sparing them of years of struggle for getting a decision in their favor. This will reduce the burden on the consumer commissions. This will amount to a respectable and authentic out-of-court settlement, yet with the stamp of the court. There is no scope for appeal once both parties have consented to and agreed to the decision. Then the statutory court fee in appeal, as Dr. Gaurav also narrated, that statutory court fee of 50% of awarded amount for filing an appeal. This should be reduced to nil or at the most 10% of the awarded amount. See, first appeal is a right which should not be made conditional. To discourage unnecessary appeals, a nominal deposit should be enough, but a deposit of 50% of the awarded amount is huge, and it implies that the lawmakers want to discourage appeals. Many decisions are rightly set aside or reversed in appeals as a means of inherent checks and balances in the judicial system. Discouraging appeals is very unjust and will allow wrong decisions as final to make a mockery of the judicial process. Then something about petty complaints. A separate petty complaints forum under the district commission be formed to hear petty complaints, say where the consideration paid for the goods or services is less than 1 or 2 lakhs rupees. Most of our the services provided by the smaller hospitals will come under this category. Advocates should not be allowed in this small cause court proceedings. Complaint and reply should have a limit of 2 pages or some limit of words, along with up to maximum of 5 best documentary evidences, not more than 2 expert evidences, and an affidavit by each party. The judge of this forum should try to facilitate a resolution in 2 or 3 hearings and deliver decision in not more than 2 pages. It should be a summary trial in the real sense, and it should be completed in 1 month. If the case is not decided within 30 days, the court be required to give a written explanation to the district commission. If this happens more often than acceptable, that judge be acted against. Aggrieved party may file an appeal before the district commission, which would then get original as well as appellate jurisdiction. Transparency and accountability of consumer courts. This is very important. Many judgments are biased with wrong interpretation of facts, evidences, and law points, resulting in avoidable appeals and revisions. Each district, state, and national commission should have a compilation of state of their judgment, uploaded and updated every month on the official website of National Commission. All cases where decisions get set aside or reversed in the higher court, there should be some internal mechanism of audit, explanation, and sanctions. This will bring some credibility of these commissions and also compel judicious application of mind by them. This is a very important amendment that I advocate, no fault liability, and I'll talk about this in a little more detail. In no fault liability, the complainant is not required to prove any fault of the opponent. It is about proving the fault. It is difficult to differentiate between medical mishap, which occurs in spite of proper standard of care, and medical error, which occurs due to acts or omission during treatment and care. And a lot of time, energy, and money of the patients, doctors, and the courts is consumed through these litigations to establish this difference in each case. The fault-based system of tort has not served the purpose in India, causing a huge strain on resources and stress and strain on all concerned. No fault liability is already being followed in MSCT and in clinical trial regulations in India. No fault liability has been a successful model in New Zealand healthcare and in some other countries. The serious thought in its favor must be given for medical negligence litigations in India. I'll talk about clinical trial compensation as an example of no-fault liability already existing in our country. This has resulted in a successful implementation in availing speedy compensation to the injured during a clinical trial. The amount of compensation is awarded merely on proving that harm was caused. Whose fault was it is not required to be proved. The regulatory authority, CDSCO, decides on the amount of compensation on the report of the IEC and their investigator. This is to be paid by the sponsor or the insurer, irrespective of any deficiency or negligence. The claimant has just to prove the occurrence of the injury or death during the trial. The compensation amount under no fault liability may be less, but it comes more easily and more quickly. Since the fault is not required to be proved, there is no element of guilt and also less chances of underreporting of adverse events. The basic purpose of no fault liability is to get the injured back to his previous pre-injury state with quick monetary compensation. There are, of course, some conditions applied to prevent misuse of this legislation. No fault liability will imply that all adverse events will claim compensations. So proactive efforts need to be made to reduce the number of adverse events. Now, how to contain adverse events? In no fault liability, it becomes important to provide proper and frequent education to the service providers to prevent the frequent occurrence of injury. For example, in clinical trials, GCP guidelines and other guidelines help in educating the researchers and the members of the IEC. This helps in containing the adverse events. So if the guidelines are adhered to properly, the chances of adverse events and the consequent liability gets reduced. So this enables all parties to get benefited. The trial subject gets a reasonable compensation promptly without much hassles. The researcher or the sponsor is not stigmatized by a fault in his performance. Insurer gets away with relatively less amount of compensation. And this helps the cause of research because the adverse events will be reported promptly and fearlessly, decreasing the chances of underreporting. No fault liability in medical practice, clinical practice. The hospitals will need to tighten the quality of care and patient safety protocols. The training of staff and proper implementation will need to be geared up. Regulatory bodies like NMC and SMC and other professional bodies will need to conduct regular audits of medical practice and to ensure continuing medical education and provide clinical pathways for the members to follow. The doctors and staff will do well to follow the guidelines strictly in different clinical situations. The regulation of recertification after every 5 years, already under implementation, would make sure that the doctors are well updated in knowledge. This will reduce chances of medical mishaps and the overall burden of compensation. There are some apprehensions about no fault liability. The cost of regulations and education will increase. An imposition of no fault liability would compel the hospitals to increase the precautions, education and training of staff so as to lower the risks of medical mishaps and errors. However, this cost can be adjusted by adding a small amount to the patient charges. Defensive medicine, no fault liability results in the practice of defensive medicine, which increases the healthcare costs. This can be reduced with preventive health measures and public education. Inefficient system, no fault liability is considered inefficient because the fault is not pinpointed. As a matter of fact, no fault liability system is more efficient in view of quick and easy compensation without a fight. However, internal mechanisms of audit, root cause analysis, and retraining of staff will ensure better compliance with SOPs and protocols, even when fault is not the focus for compensation. Subjectiveness, compensation determination might be very subjective. This is another apprehension. The size and composition of the deciding committee can be made broad-based, and they can be given objective criteria for a more predictable methodology for compensation calculation. Indemnity insurance premiums might increase. This may be a small price to pay for the larger benefit of the no fault liability system. This can also be internalized by distributing the burden on the consumers to some extent. On the other hand, there are so many benefits of no fault system in medical litigation. Simpler and quicker mechanism for compensation to the victim, simpler proceedings only to establish the occurrence of death or injury during the treatment, no stigmatization of the doctor or hospital, insurance company gets away with smaller amount of compensation, the huge burden on courts is reduced, the social costs in terms of huge toll on time, energy and money of both the parties as well as the resources of the courts is considerably reduced. It will considerably reduce chances of underreporting of adverse events. This will compel the professional bodies and hospital managements to ensure proper measures of quality of care and patient safety through training and education as well as compliance. So in conclusion, I would like to stress that CPA 2019 is a reality. Whether it is good or bad, we have to learn to live with it. It is high time we introspect and improve our standards of conduct individually as well as those of our professional bodies. Once our credibility improves, the lawmakers will listen to our suggestions for important amendments in CPA that we desire. And it is necessary to achieve a balance in the Act, which presently is highly biased in favor of the consumers. Thank you. Thank you.